Aaron?
All-star crew today.
Yes, we do. Usually I see Aaron for ED&A. He wants to branch out. So just let me know. Are we all set?
You're all set, Senator Carson.
Okay, terrific. Thank you, Aaron. Good afternoon and welcome. I am Senator Sharon Carson from Senate District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the Right to Know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube, and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. 6, finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the Right to Know Right to Know law. I will call the roll. Senator Khan.
Present in Keene in my home. My wife is elsewhere in the house. Good afternoon.
Thank you. Good afternoon. Senator Whitley.
Good afternoon. This is Senator Whitley. I am in my home in Hopkinton. I'm alone in the room, but my husband is in the house.
Thank you. Senator Gannon.
Senator Gannon in sunny Sandown. My wife is in the house. I'm in my home office alone.
Thank you. And the illustrious Senator Harold French.
Harold French, Senator District 7, once again broadcasting live from the studios in Concord, New Hampshire, that I share with Attorney Sullivan, and Attorney Sullivan is in the house.
Thank you, Senator French. And I am Senator Sharon Carson. I am currently in my home in Londonderry, and my daughter is in the next room.
And you are also illustrious, Senator Carson.
Yes. Yeah. Oh, no. I'm just regular
you
people.
are. You're double.
Before we get started today, I would like to remind everybody, we have gotten a number of bills that we're going to hear this week. These were all the bills that we received off of the consent calendar from the House. I don't know how many we're going to get from Thursday and Friday's meeting, but I'm focused on this, and we're going to get through these this week. But I'd like to remind everyone that the deadline to report out all House bills with fiscal notes is May 13th, 2001, and the deadline to act on House bills is June 3rd, 2021. Okay, that being said, we're going to go ahead and open the public hearing on House Bill 108, FN Local. And do we have the prime sponsor, Representative Ullery, available? He hasn't signed up to speak.
I do not see, no.
Okay, is Representative Spillane here at all either?
It does not look like it.
Okay, Representative McGuire,
No.
Representative T. Leakis.
I do not see that representative either.
Does
Okay.
anyone care?
Well, I care, Senator French, and I am going to go ahead and introduce House Bill 108. Good
Thank you, Madam
afternoon.
Chair.
Good afternoon, fellow members of the Senate Judiciary Committee. I am presenting House Bill 108, FN local today for your consideration. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. This bill requires that for meetings in non-public session where the minutes or decisions were determined to not be subject to public disclosure, a list shall be kept which shall keep certain information. The list should be made available for public disclosure. Thank you very much for your consideration of this bill. I will take no questions. Next, we have David Saad, S-A-A-D.
Hello,
Yes, good afternoon, Mr. Saad.
thank you. My name is David Saad. I am from Rumney, New Hampshire, and I am also president of Right to Know, New Hampshire. This is a bill that we drafted and did get Representative Ullery and others to sponsor this bill. I ask you to support the bill. In the existing Right to Know law, it states that information may be withheld until, in the opinion of a majority of members, the aforesaid circumstances no longer apply. Those circumstances being whatever valid reason they had for sealing the minutes originally. Now, when minutes get sealed, those circumstances that justified the sealing of those minutes, as time passes, those circumstances will no longer apply. And then according to the law, as it is currently written, those minutes should be unsealed and made public. In practice, however, that is rarely the case because oftentimes the public body will vote to seal the minutes. And then, of course, as life happens, they move on to other business and future meetings, and they rarely go back and revisit minutes that have been sealed. And because they don't revisit those minutes, they never identify when those circumstances no longer apply, and their lawful obligation is to unseal them. And part of the problem is there's no easy way for the public body to identify, historically speaking, the list of sealed minutes that have been done in the past, and then put forth a process to review those minutes on some periodic basis and determine whether those circumstances no longer apply. What this bill does is it requires the maintenance of a list. So as they seal minutes, they would maintain a list of those sealed minutes, and that list would be available to them to review periodically and take action to review minutes appropriately to determine that whether they should be unsealed. So this bill does several things. Foremost, it provides a support mechanism for the public bodies to follow the existing law, which is to unseal minutes when the circumstances no longer apply. And two, it provides the public with a mechanism, this document that they can easily request to see what minutes have been sealed. And if they feel that some minutes maybe should be unsealed, they can request the public body to review those minutes. So I would ask again that you support this bill, and I want to thank you for allowing me to testify, and I'm open to any questions.
Thank you very much for your testimony this afternoon. Are there any questions? I see Senator Whitley has a question.
Thank you, Madam Chair, and thank you for taking my question. So my question is just sort of procedurally, when a public body decides to go into public session or to go into non-public, is it correct that they have to indicate that in the regular minutes, those minutes that are not sealed?
Yes, they do indicate in the public minutes that they're going into non-public. They also specify the particular exemption that allows them to go into non-public. What we're dealing with here is when they come out of non-public, they may choose to seal those minutes, and there's only certain limited circumstances where they're allowed to seal the minutes. So not all non-public sessions have their minutes sealed, only some do. When they choose to seal those minutes, that's when this bill would now be applicable, because it would require them to maintain a list of those minutes which have been sealed. And I want to point out, it only requires them to maintain that list going forward. There is no requirement for them to go back, historically speaking, and review, years of past minutes to identify which ones have already been sealed and build the list historically. That is not part of this law. It's only going forward. Once this law becomes enacted, then they would, going forward, maintain that list.
So follow up, if I may?
Yes, follow up,
So
please.
just to be abundantly clear, so if there's a decision to seal the minutes, the only minutes that are sealed are the ones that happened in non-public, but the indication that the body went into non-public, the indication in those minutes, that remains public, correct?
Yes.
Okay.
Yes,
So
yes.
the follow up.
Yes, please.
Okay, so what this bill is doing is sort of pulling out, so the information is already public, if I'm understanding this correctly, but it's pulling that out and putting it in one place in a list, correct?
Correct. Because keep in mind, over, a period of time, if you're a public body, according to the law, the public body, when elections take place, the public body, which has new members, may in fact, as we know, circumstances change over time. Things that were deemed to be needed to be kept secret for whatever valid reason changes. And the public body has to go back and review historically. These public bodies have literally decades of sealed minutes that have occurred that oftentimes they've never gone back, they've never reviewed these minutes, they've never become unsealed. People's reputations that could be impacted are not able to clear their name in any way because the minutes, kept that information sealed and they never get reviewed and made public.
Are there any further questions for Mr. Sad? Okay, seeing none. Thank you very much for your testimony, Mr. Sad. Okay, next we're going to hear from Cordell Johnston.
Thank you, Madam Chair. Cordell Johnston, representing the New Hampshire Municipal Association. We oppose House Bill 108, and I'll be honest, this bill would not be the end of the world. It is something that towns could manage to do, and I understand the point of it. But it is one more little statutory responsibility that they'll have to deal with. And that would be okay if any of those little statutory responsibilities were ever removed, but they're not. They just keep piling up, and the cumulative effect eventually becomes a burden. And by creating one more responsibility, it also creates one more opportunity for local officials to inadvertently violate the right to know law. A public body can adopt a policy about reviewing and unsealing minutes, and some of them do. Admittedly, not all of them do, but some do. And some boards already do maintain a list like this. And I would say it's a good idea to maintain a list like this, but not every good idea should be mandated by law. And I guess the question is, for the additional work that this will create, is it really worth it? And who's going to benefit from it? I guess it will benefit the person who, for whatever reason, wants to see a list of all of a board's sealed and non-public minutes. They still don't get to see the minutes themselves because they're still sealed. So I'm not sure what good the information will do anyone. And yet the bill would require that the literally thousands of public bodies around the state compile this information. And keep in mind that the information is already publicly available. It's just not in a list. So it may take a little digging to find it, but it is available because the law already requires that the public session minutes include the information that would be put into this list. So if I go into the town hall and I want to see where the Board of Selectmen has sealed their non-public minutes, I can get that information. Again, it's not in a list, but the information is available. And please understand, the point of the right to know law is not to require public officials to create more records, as this would do. The point is to require that the records that do exist be made public. In fact, the law expressly states nothing in this chapter shall be construed to require a public body or agency to compile information into a form in which it is not already kept or reported. And this goes against that by requiring the public body to create a new record. I guess my concern is if you require public bodies to compile this information into a list, what's going to be the next requirement? So, as I said, it's not the end of the world. It's something that towns could deal with if they have to, but it is going to require more work. And I don't really see that it creates a significant benefit. So for those reasons, I ask you to find the bill inexpedient to legislate, and I'm happy to answer any questions. Thank you.
Thank you very much, Mr. Johnston. I see Senator Khan has his hand raised.
You're on mute, Senator Khan.
Senator Khan, we can't hear you.
Hey, it takes me once per meeting. And
Senator Khan, we have a very long week this week.
Yeah.
So.
All right. So thank you. Mr. Johnson, I'm wondering about the unanticipated steps that this may create. And so my familiarity with closed minutes, non-public meetings have been lawsuits. We're getting sued. We've got a personnel action that is caused us to go into non-public, or a piece of property or transaction that needs to be sealed for a time. I can envision that in each of those circumstances, that non-disclosure agreements or clauses would be added to those negotiations and agreements, and have the effect, if public bodies wished to continue to seal records, that they would do so through that kind of an agreement. Do you think that is a circumstance that would interfere with the implementation of this?
I'm not sure I understand. I think you may be thinking of another bill that the committee has coming before it, dealing with non-disclosure, dealing with non-disparagement clauses in settlement agreements.
I might be confusing the two, but intentionally so.
Okay.
And the point is that in a termination agreement, you can have, which is a non-public session event, you can have a non-disclosure
Yep.
to that negotiation.
Yep.
You can have that in a lawsuit that is pending negotiation and settlement, and you could have a non-disclosure section to that agreement.
Yep.
And you could as easily, the negotiations, the asking price, the agreed to price on a property, you see where I'm going? I hope that made it clearer. Would that inhibit the intention of, and it's just a sense that if you really did not want to disclose, then you would be adding these kinds of clauses to your agreements. Do you agree with that?
I do. Yeah, I do agree with that. I'm not sure that this bill would interfere with that, and I don't want to overstate my case against the bill, because the bill doesn't change what is and is not allowed to be sealed, or what is and is not allowed to be discussed in non-public minutes, in non-public session. You still have to comply with 91A3, which says you can only go into non-public session for these purposes, and you can only seal the non-public minutes under these circumstances, and you unseal them under these circumstances. So I don't think the requirement of compiling a list of those sealed minutes would interfere with that. But I mean, I am certainly sensitive to the concerns that you're talking about.
Thanks.
Are there any further questions for Mr. Johnston? Senator French?
Thank you, Madam Chair, and thank you, Mr. Johnston. So do I take it that your biggest objection is this will just be burdensome to the towns to create the list, or to maintain it, or to keep it?
That's the concern. It doesn't change the substance of the law. It just requires towns to, it is the burden to do that additional work to create that list. And as I said, once you start saying you have to create this list and that list, where's the end of that? And that's not really what the right to know law was designed to do.
Okay, thank you.
Are there any further questions? Mr. Johnston, I just want to make sure that I understand this. We already make this information available to the public, so that does satisfy the right to know law, correct?
Yes, I mean, well, assuming that the public body complies with the statute, but yeah, the statute requires that when they go into non-public session, there has to be a vote that cites the section of the paragraph of 91A3 under which they're going into non-public session. And if they're going to seal the minutes, they have to do that in public, and they have to indicate the reason that they're sealing the minutes. And of course, the date that they do that would be in the minutes themselves. So yeah, the information, and that's my point. The information is already there. It's just not in a list.
Okay, I just would like to follow up. So basically, we're asking the municipalities to duplicate what they're already doing.
Yeah, you're asking them to take all that stuff and compile it into a list. Correct.
And may I ask, where is this list supposed to be kept?
It doesn't, I guess a good question. It doesn't, I don't think it says, but because it would be a record of the public body, the statute requires that records of each public body be kept at the offices of that public body. So if it's selectmen's minutes, would be kept at the office of the selectmen. Planning board minutes would be kept with the planning board records, et cetera.
Okay. All right. Thank you very much, Mr. Johnston. Are there
Thank
any
you.
further questions? Okay, seeing none. Thank you.
Thank you very much.
Margaret, I don't have anyone else that is signed up to testify. Is there anyone in the waiting room?
If there's anyone else in the waiting room who wishes to speak, if you could virtually raise your hand. I do not see anybody, Senator Carson.
Thank you, Margaret. We're going to go ahead and close the public hearing on House Bill 108. Okay, next I am going to open the public hearing on House Bill 178 and recognize the prime sponsor, Representative Abbas.
Representative Abbas, if you could virtually raise your hand. I do not see Representative Abbas.
Okay, Senator Daniels is the other sponsor of the bill, but I know Senator Daniels is in finance. So I will go ahead and I will introduce this bill as well. Good afternoon, fellow members of the Senate Judiciary Committee. My name is Sharon Carson, and I have the pleasure of representing Senate District 14. And this afternoon, I have for your consideration House Bill 178 FN, an act relative to the parole of prisoners and the procedures of the Adult Parole Board. This bill amends various provisions of the adult parole process, including the definition of violent crime and the recommittal of prisoners who violate parole. The only other person that I have signed up to speak is the Honorable Donna Sitek.
I'm
Good
here. Can you hear me?
afternoon, Madam Speaker.
Thank you, Madam Chairman and members of the committee. Thank you for introducing the bill. Representative Abbas and Senator Daniels are both double booked for this time. So I'm here to tell you what the bill is about. I'm Donna Sitek. I'm serving my 10th year as a member of the Adult Parole Board. We requested this legislation in response to the observations of a performance audit that was conducted last year, and also to make some changes to update our chapter to improve efficiency, to assure public safety, and to reflect our actual practice. This bill was passed by the House on the consent calendar last year and went to the Senate just as COVID shut down the operation. So it was one of the bills that died on the table. So that's why we're back. It went again to the House Criminal Justice Committee, where it got a 20-0 vote, and again passed on the consent calendar. I sent you all a copy of analysis of each of the sections of the bill if you want to know why each paragraph is there. I've explained it, but I'll walk quickly through it. Sections 1 and 2 are just housekeeping provisions because there is a elimination of a cross-reference to a statute that is being repealed in this bill. Section 3, which is on the bottom of page 1 at line 30, adds a definition of violent crime. The current chapter defines non-violent crime. It says it's everything except these certain ones that are listed. But since the reference to non-violent crime, there is no reference at all to non-violent crime in the chapter. That's a remnant of a bill passed over 10 years ago, Senate Bill 500, which was a total revamp of the parole process. And at that time, if you served 120% of your sentence for a non-violent crime, you were automatically released. No parole, parole board could set conditions, but there was no question. But anyway, that has been since modified. So it makes sense to define what is a violent crime, not what isn't a non-violent crime. And that's what this bill does. You can't see what they are, but I've listed them on the handout that I sent you. The violent crimes in 651A5 are 8 crimes from capital murder, first-degree assault, right down to, child sexual abuse images. What we're doing is adding to the definition of those violent crimes, those that were in our chapter, and says these aren't non-violent crimes. We're saying they are violent crimes. So we're adding violation of protective order, second-degree assault, felony reckless conduct, criminal threatening involving use of deadly weapon, stalking, burglary, tampering with witnesses, and felonious use of firearms. All those will be considered violent crimes for purposes of this chapter. Section 4, which is on page 2, clarifies the notice requirement. Right now, if somebody's coming up for parole, the board notifies the victim, the police chief, the county attorney where the crime occurred. The audit said, well, you don't do this for other kinds of hearings. The board has parole release hearings, but the board also has parole revocation hearings. We have reconsideration hearings, and we have review hearings. Since these last 3 types can result in extending the period of incarceration for somebody who's already approved for parole, there's no need to notify the same people again. The bill makes clear that the 15 to 30-day notice requirement applies only to the release hearings. I would note that under the right to know, we provide notice of all hearings to the public. Section 5 makes changes affecting the length of recommittal. So the board approves parole for somebody and specifies certain conditions. If they don't abide by the conditions, their parole officer files a violation, and we have a hearing to determine if they should be recommitted to prison and for how long. The standard setback, the recommittal period, is 90 days. And the way the current law is interpreted is that they have a 90-day setback. You have to release them at the end of 90 days, regardless of whether they have met criteria for parole, whether they have a place to go to. I mean, they go out the door and they don't have to tell us where they're going. We would add the words that they have to meet the same criteria for parole as everybody else that we're going to release. This is the most important part of the bill from our standpoint, because the prisoners call them 90-day mandos. They know they're getting out, so it doesn't matter what they do. They don't have to tell us where they're going. They don't have to set up treatment. So we would like them to meet the criteria for parole that everybody else who's going out the door on parole meets. And I have on my handout, I had printed the criteria we use for parole. It's on the back of the handout. That's the most important part of the bill. The other parts are just updating some references to reflect our actual practice. We're eliminating a reference to the dynamic risk factors for sex offenders. We think that regardless of the nature of the infraction, whether it's a dynamic risk factor like you stop going to treatment or you're not abiding by the conditions we set, if you violate anything and you're a sex offender, we want the opportunity to give more than a 90-day sanction. Everybody who comes back who's a sex offender does get evaluated to see if they need more sex offender treatment. On page 2, line 26, we're correcting an error in the list of violent crimes. It adds the 8 crimes that we talked about before. We on page 2, line 34, we're eliminating reference to the focused evidence-based programming aimed at re-engaging parolees in their parole plan. When Senate Bill 500 was set up 11 years ago, the idea was that anybody who was released on parole and comes back should be in a separate program, a 90-day program aimed at having them refocus, re-engage in their parole plan. There was supposed to be a special program in a separate site for these people who had violated their parole. This program was never set up. So there is no focused evidence-based programming aimed at them. There is a specific program for everybody who comes back. Everybody's needs are different. So you can't plug everybody into a 90-day program. So we're eliminating that reference. But I assure you, everybody who needs a program is plugged into the one that's appropriate for their needs. Section 6 of the bill on page 3, line 35, removes the requirement that the parole board review every parolee's file every 3 years. To my knowledge, I don't know that this has ever been done because it's done by the chief PPO in each of the district offices. The idea was so that nobody gets lost in the system. Well, this is already being done by somebody else, so we're asking that you not burden the parole board with that additional responsibility. Section 7 has repeals two sections, and one is very important. Right now, the administrative rules of the parole board require us to provide an audio copy of a parole hearing. But the right to know law says that parole hearings are considered non-public. So when I came on as chair, I said, if everybody can get a copy of the parole hearing, why can't they sit in? So I opened them up to the public. And we have, to this day, we have been conducting our hearings in public. You can zoom into our meetings on Tuesdays and Thursdays and see the parole board at work. So we are eliminating that conflict between our rules and the statute and opening up specifically, eliminating the provision that says parole hearings will be done in non-public session. And we're also eliminating, the other repeal is to repeal the requirement that an inmate get a hearing 9 months before his maximum. So if somebody is doing a 3 to 6 and their behavior is so awful that they haven't had parole or they didn't have a place to go to, and it's 9 months to their maximum, right now, they are required to have a hearing, whether or not they're ready to go, whether they have a place to go, whether they've finished their programs, they have a hearing. This bill repeals the requirement for a hearing, but doesn't take away any of their rights. If we have told them you can have parole when you get an approved housing situation and you set up your treatment, come back and see us. They can do it anytime during that last 9 months. In fact, we have someone coming up for a parole hearing this week who's asking to be paroled because he's finally gotten it together. So this just does away with the requirement for a hearing, at which point they may or may not have anything that would trigger their release, but doesn't take away their opportunity to come and ask to be heard. So these changes, none of which are controversial, I hope, will enhance our efficiency, help us conform with the recommendations of the audit, and assure public safety. So I would be happy to answer any questions that you may have.
Thank you very much, Speaker Sytek. Are there any questions for Speaker Sytek? Okay, I don't see any. Thank you very much, Madam Speaker.
Thank you very much, members of the committee.
That was very helpful, Madam Chair.
Okay, Margaret, that was the last person I had who had signed up to testify. Is there anyone else?
If anyone else would like to testify, if you could virtually raise your hand. I do not see any hands raised.
Okay, before I close the public hearing, I will announce that we had 7 people sign up in support and no one had signed up in opposition to this bill. So I'm going to go ahead and close the public hearing on Senate Bill 178. Okay. Next, I am going to open the public hearing on House Bill 239 FN and recognize the prime sponsor, Representative Abramson.
Are you folks able to hear me?
Yes, we are.
I'm still not used to the Zoom stuff. I guess we're coming out of the Zoom thing pretty quick here. So my name is Representative Max Abramson. I'm reintroducing House Bill 239. I did bring this. The bill essentially extends the statute of limitations for an attack on a child, anyone under the age of 18. Right now, if someone commits felony assault, first-degree assault or second-degree assault under the statutes, if the child is 10 years old, then the statute of limitations runs out when the child is 16. And we have other laws on statute of limitations where we don't start the clock until the victim turns 18. So I thought that to make this clearer and to make it more consistent, it makes sense. I absolutely believe in the need for the statute of limitations. The New Hampshire Supreme Court gives very good reasoning for why we have it. But the statute of limitations is kind of a 6-year clock. it's an amount of time where the victim can come forward, has a realistic chance to come forward, where the police can start their investigation, decide whether or not to prosecute the case, and then go to either the police prosecutor, the county attorney, or the attorney general's office to have the case some type of follow-up, and in rare cases, federal prosecutor. The problem with just starting at age, when at the time of the attack, is that very young children often don't know who to report it to, don't even report it to a teacher or parent. They don't understand how the process works. They're not aware of the statute of limitations. And in a majority of those cases, the person who attacked them is either a relative, a teacher, a babysitter, or some other authority figure in their life. And so realistically, the statute of limitations, the clock is running, but there isn't a realistic opportunity for the victim to come forward because they might even still live with their attacker. And they generally don't have much knowledge of how the criminal justice system works. So it makes sense, as we do with felony sexual assault, there the clock doesn't start running until the victim turns 18 and they have a chance to at least be out on their own and be some way physically separated from their attacker. In this case, it makes sense to start the statute of limitations for first-degree assault and second-degree assault when the victim turns 18. That gives the police, the investigators, the detectives, and the prosecutor a more realistic window to go after them. The criminal justice system is supposed to do three things: reform, deter, and punish. Our system's come under some criticism recently on the reform part because of our high recidivism rate, but it certainly does. It certainly is doing the punishing and the deterring effect. But the deterring effect, which is what we're really going for with this bill, House Bill 239, is to make sure that someone who's thinking of committing a really serious attack on a child that they don't do it, that it gives them a pause to realize that there's going to be a longer period of time, and that we know, for example, this came up on the sex worker bill case on the House side, that there are criminals who specifically target sex workers because they're easier targets and they have a tougher time reporting crime coming forward. And I think that there are, I don't have studies on this, but there are people who go after children because they realize they have a less chance of being prosecuted for hurting children. And I think that having the statute of limitations, delaying the clock until the victim is 18 and they have a realistic chance of coming forward, it just made sense to me. This did pass both years. It passed 20-0 in the House Criminal Justice Committee, and both this year and last year, it went right to the consent calendar, and there's not a single word of opposition to the bill. It did open a couple of other questions relating to RSA 631 sections 1 and 2, first-degree assault and second-degree assault. But I think that those questions or those issues are outside of the scope of the statute of limitations. And I think that any reopening of that should be done with the bill for next year. And with that, I'll take questions.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Margaret, there was only one person signed up to speak. Is there anyone in the waiting room?
There is not. If anybody else would like to testify, if you could virtually raise your hand. I do not see anybody.
Okay, thank you, Margaret. I'm going to go ahead and close the public hearing on House Bill 239 FN. Okay, let me check and see what time it is. Okay, we're now right on schedule. This is pretty good. Okay, this one might take a little while. I will announce on House Bill 239, there were 2 people that had signed up and they were both supporting the bill. I will now go ahead and open the hearing on House Bill 270. and recognize the prime sponsor, Representative Conley.
Good afternoon, Madam Chair, Senators.
Good afternoon, Representative.
Okay, my kids are downstairs watching Netflix and they're sucking up a lot of bandwidth, so how to get
It's
through.
okay.
Um,
It's a been there, done that kind of thing.
okay.
I feel you. I feel you.
So yes, Casey Conley, State Representative from Dover, representing Stratford County District 13, here now to introduce HB 270. This bill contains some modest enhancements to New Hampshire's existing post-conviction DNA testing program. The version before you today left the House Criminal Justice and Public Safety Committee with a 20-0 OTP recommendation last year and the same 20-0 recommendation this term. The language contained in this bill does a few important things. First, it clarifies the existing statute for how someone would petition for this type of redress, specifically in which court they would make the application. It includes a provision to assign an attorney to someone who pursues this type of relief, but only if they meet the existing rigorous requirements to qualify. It clarifies the process for testing the biological material, what labs would be used for the purpose, how the results would be shared with the state and the person seeking the testing. And lastly, for petitioners who satisfy the criteria to be granted a hearing, it modifies the standard that person must demonstrate for a judge to order the testing. So it would move that standard from clear and convincing, which is a very high bar, to a preponderance of the evidence, which is the standard used in the federal judicial system. One other important note, this bill lets people who are on parole or who have completed their sentence, who assert their innocence, to request this type of relief as well in an effort to clear their name. And again, this person would have to meet the same rigorous criteria as anyone else. A little context here, I suspect the committee is aware of, but I'll say it quickly. Although many of us are used to sort of the CSI model of DNA material and biological material, the reality is very few criminal cases have DNA or other biological evidence. We're talking about a very small number of cases, nearly all of which relate to crimes like sexual assault and murder. The number of cases where the evidence would potentially exonerate someone is even smaller. We've seen, numerous accounts in the media of people who have been exonerated in other states after serving long sentences. That's never happened in New Hampshire. There's never been a DNA exoneration in the state. I like to think that everyone who has been sentenced in our state, past or present, was innocent, but the data suggests otherwise. Passing this bill, again, gives someone who finds themselves in the terrible situation of being wrongfully convicted a clear path to seek their freedom, but with existing safeguards already in the statute that would protect the state against frivolous claims. This bill does contain a fiscal note, but if you read the fiscal note, it makes clear that the fiscal impact for testing and court hearings and legal costs, given how few petitions there are likely to be, all of those could be handled within existing workloads and existing budgets. So I would hope the committee would look fondly on this bill. Happy to take questions, and also note that there are people, I think, testifying after me who are far more expert in this than I am. So thanks very much, Senators.
Thank you very much for your testimony this afternoon, Representative. Okay. Are there any questions for Representative Conley? Senator Khan.
Thank you, Madam Chair. Thanks, Representative, for bringing this forward and explaining it as well as you have. Were there other groups that you worked with in bringing this forward?
Thank you, Senator, for the question. So this bill, although I am the prime sponsor, much of the work was done by our Democratic leader, Rennie Cushing, who, after his election to lead the party in the House, handed off a number of bills. This is one. The Innocence Project has been a wonderful help with this, and a number of other groups, folks involved with UNH and so forth. So this was certainly developed with the sort of the leaders in this realm.
And I see we're going to hear from the Innocence Project. So good. Thank you.
Okay, are there any further questions? I see none. Thank you very much, Representative.
Thank you.
Next, we are going to go Cynthia Musso. I hope I got that right.
You did, and it's very rare that people get that right. So you get double points today. So I'm Cynthia Musso. I'm a staff attorney at the New England Innocence Project. I'm actually the first New Hampshire-based attorney from the New England Innocence Project ever. And I think this bill is so important because the potential impact for this bill is so great for folks that would be wrongfully convicted here. And the negative side effects of this bill are minimal, if any. The practical reality is that the statistics show nationally that we are just sort of not, we are not reaching the people that are being wrongfully convicted in New Hampshire. They don't add up. And the reality is that this bill is the current statute is so limited that it's not allowing access to testing for some folks that should be able to access that testing. And this expansion would allow for those folks to be able to access that testing, which is so important. DNA changes, science changes, forensics change so quickly. We want to make sure we're doing things right. We want to make sure we have the best and most accurate science in our courtrooms, and we want to make sure that we're not relying on anything that's not the most up-to-date technology available. I think this bill has, as Representative Conley mentioned, a big impact for a very small cost. I was a public defender in the state for between here and Massachusetts, which is where I was first a public defender, about almost 10 years. And I know that there are folks, I know that there are folks that are in prison for things that they haven't done. And I really think that the DNA bill is going to be potentially helpful for some of those folks. And I would, highlight that the majority of, as Representative Conley mentioned, the reality is that DNA evidence just isn't involved in a lot of cases. It's not collected and it's not relevant. So the practical reality is this bill really doesn't apply on its face to 90% of cases that are in New Hampshire in the first instance. So I think this is would be really helpful and would really move the ball for a lot of wrongfully incarcerated folks.
Okay, thank you very much for your testimony this afternoon. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Attorney Musso, for taking my question. So I want to go back to something you mentioned earlier in your testimony about how there's national data saying how many folks we should be seeing in New Hampshire who were able to exonerate themselves. So I'm wondering if you could flesh those numbers out a little bit more.
So, I mean, I'm always reluctant to give actual numbers, and, I don't know the actual numbers across the state, but what we do know is that 0 DNA exonerations in a state is just not reflective of the actual number of wrongful convictions based on DNA in the state. It's just that number is it's unrealistic. It's magical thinking, right? So it's just like the number that I'm focused on is less the number, although the fact is that there's been DNA exonerations in most other parts of the state or country, but the reality is the number 0 is the one that's the most concerning to me.
Thank you, that's helpful.
Okay, are there any further questions for Attorney Musso? Okay, seeing none, thank you very much for your time this afternoon. Next, we're going to go to Elizabeth Powers.
Hello.
Hi, good afternoon.
Hi, great, it worked. I'm glad you can hear me. Thank you so much for allowing me the opportunity to speak. My name is Beth Powers, and I'm the state campaign director for the Innocence Project. So we're a national organization dedicated to exonerating wrongfully convicted people through post-conviction DNA testing and reforming the criminal justice system to prevent future injustice. And As you just heard from the prior speakers, there have been 375 exonerations based on DNA nationally. However, none of those have been in the state of New Hampshire. So this bill would clarify and modernize the current process for seeking DNA testing post-conviction. But I want to be clear, this change would not make it any easier or lessen the standard by which a conviction is overturned. Rather, it simply creates a clearer path for obtaining the actual DNA testing. So these changes not only benefit the wrongfully convicted, often in the course of settling innocence claims, the actual perpetrator of a crime is identified, and therefore that prevents future crime from occurring. So what we've learned from the 375 DNA exonerations is that the true perpetrators of those crimes, so the person who was out free while the wrong person was behind bars, was subsequently detected in 44% of those cases. So in those instances, while a wrongfully convicted person was sitting in prison for a crime they didn't commit, there's a known 165 real perpetrators that went on to commit significant violent crimes, 36 murders, 83 rapes, 35 other violent crimes that could have been prevented if the right person had been detected and the innocent person freed at an earlier date. So changes to the existing testing law would enable justice for the few people who've experienced the unique horror of wrongful conviction. It's only a few people, but for them, it's monumental. The impact of this bill would be huge. I've provided you with written comments that detail the changes throughout this bill and give you the national context, how each one compares to other states. In the interest of time, I'm not going to go through in that detail right now, but if you have questions, I'm more than happy to take them.
Okay, thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you very much, Ms. Powers. Next, we're going to go to Albert Scher.
I assume I'm on at this point.
You sure are.
Thank you, Madam Chair and members of the committee. I'm Albert Scher. I'm from UNH Law. I won't make any further lengthy introduction since I've been in front of this committee before. I would say that I've been handling DNA cases for, at this point, over 30 years. I handled the first DNA case from the defense perspective in New Hampshire back in the early 1990s. So this is foursquare my area of expertise. I'm going to be very brief and refer you to my written testimony for more comprehensive thoughts, but I want to point out two things, and only two things. I am one of the few living examples of an attorney in New Hampshire who has tried to use the current post-conviction DNA statute. I represent an individual who's incarcerated on a life sentence on a murder case for 13 years, trying to get post-conviction DNA testing. And we tried to do it through the existing statute, and it took us 3 years to work our way through the existing statute, given its messiness and its vagueness in relation to other statutes and a variety of time limits that apply. And I probably put in somewhere between 40 and 50 hours, all of it pro bono, 40 and 50 hours just working on the issue of sorting out the statute and trying to get post-conviction DNA testing, which eventually we did. But the statute needed improvement, and what's before you improves the statute in a very meaningful way in terms of the really unnecessary roadblocks that we encountered in our effort in the case I worked on. Second point I would make is I second what everybody said about there's just not that many cases out there where there is forensic there's a biological sample available for DNA testing. It's been said that it's mostly sexual assaults, maybe a few assaults, maybe some homicides. Those are the huge majority of the cases. There's a clearinghouse out of Northwestern whose name is leaving my mind. I can't remember, that documents all wrongful convictions established in the United States and there's over 1,000 of them. The Innocence Project, for good reason, looks at just the DNA exonerations and wrongful convictions, but this is a real phenomenon. That said, there's not going to be a wave of people taking advantage of this new statute if it is passed. Just the numbers are not there. I've done a survey of criminal defense lawyers in New Hampshire, an informal survey, to ask how many of them have ever handled a case under the current post-conviction DNA statute, and none of them had. So it's a difficult proposition. It's a particularly difficult proposition for people who are in jail because it's hard to get counsel. And it's hard to understand how to meet the burdens in the statute. And the great value of this update and clarification is that it will make, at the front end, give them a better opportunity to have a fair shake at, if they deserve it, at post-conviction DNA testing. That said, I'll refer you to my written testimony for anything further, and willing to answer any questions.
Thank you very much for your testimony, Attorney Scher. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Margaret, that's all the folks that I have signed up. Are there people waiting to testify in the waiting room?
If anybody else would like to testify, if you could virtually raise your hand. I do not have any hands raised, Senator.
Okay, thank you. Thank you, Margaret. Before I close the hearing, I'd just like to announce that 71 people signed up in support of this bill and 1 person signed in opposition. That being said, I'm going to go ahead and close the public hearing on Senate Bill 270. Okay, I think we're good. I have 202, so I think we're good to start the next public hearing. Okay. I am going to go ahead and open the public hearing on House Bill 296 FN and recognize the prime sponsor, Representative Nutting Wong.
Hello, committee.
Good afternoon.
Hello. I am Representative Allison Nutting Wong. I represent Nashva's Ward 5, and I'm here to introduce HB 296, establishing the crime of unsolicited disclosure of an intimate image. This is more commonly known as cyberflashing. This bill, if it were to become law, would make the unsolicited sending of genitalia via electronic device a violation, with multiple offenses being a Class A misdemeanor, punishable by a fine of up to $1,000. This law would be placed in the harassment laws, as cyberflashing is harassment. I have received these unsolicited intimate images before, and it is incredibly violating. It's illegal to flash someone in person, and I believe that it should also be illegal to do so digitally with a footprint. There was a study in the Journal of Sex Research titled, "I'll Show You Mine If You Show Me Yours." This study found that about half of the men in the study admitted to sending unsolicited pictures. Most of the men sent the pictures in hopes of receiving a picture back or to entice a partner. However, about 10% of these unsolicited senders agreed with the statement, "Sending dick pics gives me a feeling of control over the person that I've sent it to." And nearly 6% agreed that I feel a sense of dislike towards women, and sending dick pics is satisfying. Regardless of the reason for sending, the action of sending these images is harassment, with nearly no recourse for the people who receive them. When I receive a message or an email, I expect to have a conversation, not send graphic images with no warning. These images are often sent without prior contact, purely to get a response. When I've received one, the advice I'm given is to block the sender. Indecent exposure is a similar crime with often no proof, with similar recourse as I'm asking in this bill, but a cyberflasher can send many more images at a time. And with the proof right there on your phone or via message, this is why I think it's a similar action and therefore similar crime with similar recourse. So I'm willing to take any questions, and thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, Senator French.
Thank you, Madam Chair. Thank you, Representative. Does this bill, I couldn't see it in it, does it make it a stiffer crime if it goes to a minor?
Thank you for your question. The crime, so that's actually already a crime. I believe it's a felony though. But
Okay.
right now, if you were to, yes, it's a crime.
Thank you.
Senator Khan had a question.
Thank you, Madam Chair. Thank you, Representative, for bringing this forward. So I'm reading this bill as showing somebody in a naked photo or image, and what I was wondering is we must have another statute that is dealing with other type of revealing photos that perhaps a person is not naked, but or in a sexually explicit act, but is in an embarrassing unclothed or partially clothed manner. So is that in another statute that we cover that?
Thank you for your question. We do have like a revenge porn law. When someone's sending an image of someone else. And I forget exactly which RSA that is, but that is already a crime, a felony, I believe.
Okay. I did poke around a little bit overnight to look at where that might be located. Thanks for trying that question, and I'm glad to know that that's also covered in our statutes.
Yes, I actually had to explain to OLS the difference between the two. It was a very awkward conversation.
Yeah, it's an awkward question to ask. So thanks for taking the question. I'll look for the statute. Thanks.
Are there any further questions for Representative Nutting Wong? I have a quick question for you because I read this and I had actually worked on the legislation concerning revenge pornography, and I agree it can be a difficult and somewhat embarrassing type of conversation, but unfortunately our society today, people love to take pictures of themselves, and they don't sometimes realize what can happen to those photos. But the question I have for you is, can this be used as a defense when someone has been caught with child pornography images on either their computer or on their phone or some sort of electronic device? Can they say, well, you know, hey, I didn't solicit these pictures, someone just sent them to me, and that can be a defense to a charge of possessing child pornography?
Thank you. I had not thought of that.
Okay.
I would certainly hope it would not come up ever.
Okay. Well, you know, sometimes I think we all know individuals can be very interesting. So I was just curious about that. So, okay. Are there any further questions for Representative Nutting Wong? Okay, seeing none. Thank you very much for your testimony this afternoon. Margaret, she was the only person that had signed up to testify. Is there anyone in the waiting room?
If anybody else would wish to testify, if you could virtually raise your hand. I do not have any hands.
Okay, thank you. Before I close the public hearing, I would like to announce that 39 people signed up in support and there was no opposition to the bill. And so I am going to go ahead and close the public hearing on House Bill 296. And it's 2:10. We have 5 minutes to the next public hearing. So I will put the committee in recess for 5 minutes and we will be back at 2:15. Thank you.
Senator.
Okay, let's hopefully people will start to come back. I have 215. I think we all are coming back.
The revenge porn statute that she was referencing is 644:9.
Okay.
Anybody's looking for that?
But I think, Rick, that we're talking about two different things here.
Yeah, it just came up in the course of the discussion, that's all.
Okay, all right. Did you get that, Senator Khan?
Yeah, I'm just, Rick, is that the statute that's being amended or the other one that covers?
The other one, it's the revenge porn statute.
So the one that's not covered by this.
Correct, it's one that exists, yeah.
Yeah, that was 640.
644:9-A.
Thank you.
Okay, seeing that it is 2:16, I'm going to bring the committee out of recess, and I am going to open the public hearing on House Bill 615 and recognize the prime sponsor, Representative Seaworth.
So it says that I cannot allow him to speak because he's using a older version of Zoom. Can I promote him to panelist? Okay.
Good afternoon, Representative Seaworth.
Good afternoon. Thank you, Madam Chair, and thank you to the committee for hearing my bill. I apologize for that. I'm using a Chromebook, which doesn't play well with Zoom sometimes, but we've got everything working. For the record, my name is Representative Brian Seaworth. I am from Pembroke, and I represent the district that includes Pembroke and Chichester. I am introducing HB 615, a bill of which I am the prime sponsor. First off, a little bit of history on this. This is language that the House had passed in the previous term. It made it over to the Senate, after which it died on the table in the Senate before it had a chance to be heard. That was 2020. I don't think it needs any further explanation. So this term, to help expedite the process, we actually took language from two different bills that had passed the House, combined them together into a single 2021 bill. And although the two bills had a slightly different focus from each other, they are both amending the same section of the law, which is within the Controlled Drug Act, 318B, and Section 26(6), which specifies penalties. Also, in combining these two bills, in addition to making it a little easier to work through them in around the difficulties of scheduling committee meetings, it also combines work in a truly bipartisan manner. The one part of the bill that focuses on maximum sentences was originally sponsored by Representative Connolly, who is a co-sponsor of HB 615. For what I like to call my portion of the bill, the part of the bill that deals with the first offense sentencing, that was language that I originally submitted. It was worked on extensively by the House Criminal Justice Committee over the summer in 2019, and another version of the bill was resubmitted by the members of that committee. So bottom line, this is a genuine bipartisan effort. The goal of this bill is to rationalize penalties which are specified for non-violent drug offenses. What it does is adjusts the range of sentencing to correspond more closely to what is actually taking place in our courts. So I don't think of this as a soft on crime bill by any means. For the typical penalty, it will not be affected because it would still fall within the adjusted sentencing requirements. What this bill does is eliminate some of the extreme upper penalties, limits that almost never or never would actually be used. So briefly, the bill has 4 different parts to it. First of all, the title of the bill indicates that first part, which is it eliminates a felony charge that currently exists in law for first-time simple possession offenses. It changes that first offense to be a misdemeanor rather than a felony. Second, it deals with several cases of the maximum, it deals with several cases of the minimum sentencing, minimum sentences for various drug offenses, and this is a policy that I think throughout the country is shown to be counterproductive. Third, it reduces some of the maximum sentences, both in terms of the prison terms and the fines for possession with intent to sell. And again, this is an effort to bring the RSA back in line with what actually takes place in the court. The fourth item is goes in the opposite direction. When the bill was dealing with this maximum sentencing was originally heard in the House, there was some concern about how it would apply to fentanyl. We've all seen the stories of how dangerous even very small amounts of the drugs can be, and there was some concern that it wasn't treated differently than, say, heroin. So an amendment was added to the bill during the 2020 session, which addresses that concern. And while the upper penalties are being lowered, the amounts that would trigger those penalties have also been lowered so that it addresses fentanyl more strictly than it does some of the other substances. Now, this language has now passed the House multiple times on voice votes, both in 2020 and now again in the 2021 session. As I said, it represents a good bipartisan effort. I think it advances some sensible and modest drug reform. I believe this is good policy for New Hampshire, and I ask the committee to recommend support. Thank you. I'd be happy to answer any questions. I'll also note I expect that there will be some experts on the legal and other details following me. So some of the harder questions you might save for them. If necessary, I'll be on for the entire hearing and you can bring me back if something that you expect to be answered doesn't get answered.
Okay, thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none. Thank you, Representative.
Thank you.
So, Senator?
Yes.
Unfortunately, because Representative Seaworth had to be promoted in order to speak at the hearing, we can't, the only options we have are either to leave him on the Zoom with us with his video off, or to remove him and have him rejoin again as a member of the public. It's up to your discretion how you want to move forward.
No, why don't we just leave him as a panelist? But, you know, that way, if anyone at the conclusion would like to ask him any questions or something, we don't have to go through this process again.
Okay, perfect.
Okay, why don't we go to Joe Hannon?
Joe, if you could virtually raise your hand. I do not see Mr. Hannon.
Okie doke. Let's go to Joseph Lascaz.
Hello, can everyone hear me?
Yes, we sure can.
Okay, thank you.
Welcome
Thank you.
back to the committee.
Yes, it's been a while. Thank you, Chair and members of this committee for hearing my testimony today. My name is Joseph Lascaz, and I will be representing the American Civil Liberties Union in support of HB 615. We do want to acknowledge that there are several sentencing and financial provisions within the bill. However, my focus today will be on the provision related to reducing the possession charge from a felony to a misdemeanor. Substance misuse is a disorder that can affect anyone, anywhere. It doesn't care gender, race, where you live. And New Hampshire has experienced an opioid crisis, and we're still dealing with the ripple effects today in our communities. From personal experience, I can tell you that a felony record can be, and oftentimes is, a permanent consequence to what could be a temporary situation where a person needs only a wake-up call, help, and guidance on correcting their current trajectory in life. And I do want to underscore that this bill and this provision would only apply to possession charges. It does not apply to trafficking, not to distribution, and not to sales. This legislation, it just gives an opportunity for someone at a crucial crossroad in life to have the ability to switch lanes while still balancing community safety. And in closing, I just want to say that I hope New Hampshire takes this opportunity where we can have this approach where we endeavor to help treat substance misuse as an underlying condition rather than criminalize it, especially when someone has their first initial brush with the criminal justice system. It's for these reasons stated that we support this legislation and ask that this committee vote ought to pass on HB 615. I'm happy to take any questions that you may have with me.
Thank you very much for your testimony this afternoon. Are there any questions? I see Senator Whitley has a question, then Senator Gannon.
Thank you, Madam Chair, and thank you, Mr. Lascaz, for your testimony and for taking my question. So just to be clear, so I'm reading this correctly, this is about possession and does not apply to, if you're selling or if you're, doing something else, bringing across state lines. This applies to possession, correct?
That is correct. Thank you for the question. This would apply to personal possession, and that possession charge would be determined by a prosecutor after evaluating and looking at the case. They would be the ones that would have made that determination. This does not apply to interstate trafficking, distribution, kingpin, any of that. It does not apply to. This applies to the possession, the personal possession portion.
A follow-up, if I may?
Yes, please.
Thank you, Madam Chair, and thank you, Mr. Lascaz. And also, you had mentioned in the previous witness had testified about, we are in the middle of an opioid crisis. We do know that we have folks in our jails that, perhaps need treatment rather than incarceration. So I'm wondering, how this bill sort of factors into, our ability to get folks treatment.
Thank you for that question. So what this would do is it would provide opportunities for alternatives to incarceration that may not be available if a person were to have a felony record. I will be submitting written testimony after the hearing, and I can include more to answer your question on that specifically, the testimony.
Thank you.
Okay, thank you. Are there, Senator Gannon had a question.
Yeah, just a quick question. Mr. Lascaz, we're back next Thursday, so if you get a chance, stop by my office.
Okay.
But just a question for you. Most people how do they afford the drug habit? So most people who possess, is it not true that most people are selling to pay for their habit? Or is that just a urban legend?
So that's a good question. I can only speak from personal experience. I don't know what the majority is, but I do know people who have gotten further down the criminal path that started, out of a use, and then in order to support that use, it snowballed further. But if their use had been treated at the initial stages, they, could have avoided a much different trajectory.
Thank you, Mr. Lascaz.
Are there any further questions? Mr. Lacoste, I need a point of clarification.
Sure.
Senator Whitley had asked a question about who this is going to apply to, and you had answered that this was going to apply to somebody who just had personal drugs for personal use. But I'm looking at the bill, and I'm looking on the first page, line really 2 and 3 under the first act. Here it says Controlled Drug Act penalties. It says any person who manufactures, sells, prescribes, administers, or transport or possesses with the intent to sell. We're not talking in that instance about someone who has drugs for personal possession. And that language is also repeated on page 3, beginning on line in section 3, which begins on line 25. If you look at line 27, it's basic. It says, or possessing with the intent to sell, dispense, or compound any controlled drug or its analog. So I think we need some clarification here. Are we just talking about individuals who have a small amount of drugs for personal possession? Are we talking about people with the intent to sell? Because that's the way that it's reading in the proposed legislation.
Thank you, Senator Carson, for that question. Yes, I can see how it may be stated that way. Where I'm looking at is under, I don't know how to, I think that it's under controlled drug penalties. It's halfway down, and it's under section A, it strikes the language where it was talking about specifically a Class B felony, going down to a misdemeanor. And that was for, where it says in the case of a controlled drug or its analog, other than those specifically covered in this section, the person shall be guilty of a misdemeanor, except that any person who commits any. So the way that I interpreted that is that this was only for the control, because it's talking about in the case of a controlled drug or its analog, which would be a possession charge, not manufacturing, distribution, or sale.
Okay. All right.
Hopefully someone with a legal degree can shed more light on that later on.
We'll tackle it. We'll try to figure it out. It just didn't seem to fit well, but that's okay. We'll make sure we understand it before we actually get to vote on it. So, are there any further questions for Mr. Lacoste? Okay, seeing none. Thank you very much. Next, we're going to go to Ross Connolly.
Thank you, Madam Chair. Can you hear me?
Yes, we can.
Excellent. Well, thank you for having me today. And thank you, Madam Chair, and the members of the committee for holding this hearing. For the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire. And I'm here to voice our support for HB 615. I'll be brief since I can't provide a lot of the details, some of the legal aspects, but I don't want to be repetitive and I want to be respectful of your time. Simply, HB 615 would prioritize drug treatment and rehabilitation over punitive sentencing for first-time simple drug possession. As we know, substance abuse is an issue that impacts many Granite Staters, and we as a state must be critical of our existing policies to derive what works and what does not work in combating addiction. First-time drug possession should not result in a lifelong setback, but instead we should look at more effective measures that we can take to address addiction. And this bill simply makes small incremental changes to drug possession statutes to prioritize that effective treatment over punitive sentencing. Many of these changes, they are not massive changes to drug laws. Lots of changes to the amount of fines that can be levied and maximum and minimum sentencing. It simply gives judges more discretion in sentencing and gives addicts that opportunity and chance to change their lives around for the better after a first-time run-in with a drug crime. We believe there can be a life after addiction, and we should give that opportunity to struggling Granite Staters who have unfortunately fallen into a life of dependence on drugs. And for these reasons, we urge the committee to move HB 615 ought to pass. And I'd be happy to answer any questions to the best of my ability.
Thank you very much for your testimony this afternoon, Mr. Connolly. Are there any questions from the committee? Okay, seeing none, thank you again. Next, we're going to go to Jake Berry.
Yes, good afternoon, Madam Chair. You can hear me okay?
Yes, we can.
Yes, wonderful. Thank you, Madam Chair, for having me, honorable members of the committee. My name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We've been working for more than 20 years to address alcohol and other drug issues in our state. I don't want to repeat too much of what's been said here this afternoon, but I do want to emphasize New Futures' strong support for HB 615. New Futures has come a long way in recent years, recognizing substance use disorder for what it is, a chronically relapsing condition of the brain. And with the wisdom of so many of you here in the legislature, we've worked in turn to enact public policies and systems that increase access to treatment for those in need, rather than sticking them in jail or prison. Those efforts have helped us to gain ground against the ongoing addiction crisis, and this bill is an important next step. By reducing first-time personal possession charges to misdemeanor level offenses, and HB 615, would go far to keep individuals out of incarceration and increase access to treatment for them in their communities. It would reduce recidivism rates in our prisons and jails and would save significant taxpayer dollars. In short, this bill would play a meaningful role in helping us to overcome the ongoing addiction epidemic and to preventing the next one. We urge you to vote this bill ought to pass, and I'm happy to take questions.
Thank you very much for your testimony this afternoon, Mr. Berry. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you, Jake, for taking my question. I wanted to just learn more about what you said about this type of bill reducing recidivism. Is that because you're getting folks into treatment? How would this bill impact the reduction of recidivism?
Sure. Thank you for the question, Senator. I think it addresses that in a number of ways. Number two, we do know that the earlier that we can help people to access treatment for their substance use disorder and surround them with the supports they need, the more likely they are to maintain obtain and maintain long-term recovery. And while certainly there are relapses that can come with that, they are within a treatment community. They have access to the resources they need and are less likely to pursue further levels of drug use, or to Senator Gannon's point, to engage in drug sales later down the road. If that answers the question.
It does.
Are you all set? Okay, great. Senator Gannon has a question.
Thanks for taking my question, Jake. Do you have any hard numbers on the recidivism being reduced by leniency or anything, nationwide or statewide?
Sure. I don't have them offhand, but certainly, we do have, drug court systems in place around the country, around the state, that do track these kind of numbers. I'm happy to look into them and report back if that would be helpful.
That would be great. Thank you.
Sure.
Great. Senator Khan has a question.
Thank you, Madam Chair. Good to see you again, Mr. Berry. I think it's a big step forward for you and the organization New Futures to be advocating for treatment. I think that's important. This bill doesn't directly address treatment. It does address very clearly sentencing. I assume that there are other statutes in place, like diversion programs, court diversion programs, and that provide that kind of court-assisted treatment, sentencing, and support for offenders. And can you just address that for a second?
Certainly, I'm happy to, and thank you for the question, Senator. Certainly, as you all know, we do have a system of drug courts in place around the state, one in every county with the exception of Sullivan County, if I'm not mistaken. But those are typically directed towards really high level felony level offenses. Generally, they would not capture individuals who are experiencing a first-time possession charge. So there, in that way, there is not a diversion program available to this population, so to speak. So you're absolutely correct in that this bill does not directly address treatment, but we at New Futures and so many of our partners in the community believe that individuals are best able to access and successfully complete treatment when they are at home in the community and not involved in the criminal justice system in that way. We know that certainly our prisons and jails have gone far to increase the modes of treatment available in-house, but that's still very much a work in progress, and certainly sort of success and completion rates are vary around the state, as we just think that is not the best, most proper, healthy atmosphere for engaging in substance use treatment. And the last thing I would like to note that I should have said earlier on, by eliminating this as a felony level offense, you are getting rid of certain obstacles that individuals who are in recovery face in terms of we know that stable housing and stable employment are absolutely critical factors contributing to an individual's long-term recovery. By no longer saddling them with a felony level criminal record, you may be helping to contribute to removing those obstacles, helping people to obtain employment and stable housing, which will allow them to maintain recovery throughout their lives.
Okay, are there any further questions for Mr. Barry?
Thank you.
Okay, seeing none, thank you very much for your testimony this afternoon, Mr. Barry. Next, we're going to hear from Justin Odler.
Justin, if you could virtually raise your hand.
Hi, this is Attorney Jeff Odlin from the New Hampshire Association of Criminal Defense Lawyers. I just want to make sure I'm the right person to be speaking right now.
Yes, you are.
Okay, thank you, Madam Chair. Thank you for allowing me to speak in regards to the bill. I am here as a board member of the New Hampshire Association of Criminal Defense Lawyers. I am a criminal defense lawyer who resides in Francistown, New Hampshire, and I've practiced in the state of New Hampshire for the last 13 years. During that time, I've had the opportunity, both as part of the public defender system and in private practice, to represent hundreds of individuals struggling with substance misuse disorders and finding themselves before our courts facing criminal charges. The association, at the end of the day, supports the passage of the bill with one reservation and objection that I would like to speak to this afternoon. I think a lot of people have spoken eloquently as to some of the strengths of the bill. Probably first and foremost in the association's mind in reducing possessory offenses to misdemeanors, which could have an outsized impact for giving people a second chance. Before I lodge the association's one objection to the bill, I would just briefly respond to the concern Senator Carson brought up before when speaking to Mr. Lacasse about whether this is reducing to a misdemeanor some trafficking offenses, or if it truly only concerns possessory offenses. I would just note, Senator Carson, if you look at the section that speaks about the penalties being reduced to a misdemeanor, it specifically references 318B26, Roman 2. So in our drug statute, there's a list of offenses, which is 318B:2, and then there's a penalty section, which is at :26. And within the penalty section, Roman 1 is all the trafficking offenses. Roman 2 is all the possession offenses. And so the amendment that Mr. Lacasse was referring to is under Roman 2. So I believe he is correct at the end of the day that the only thing that's being reduced to a misdemeanor is simple possession offenses, that anything involving trafficking or possession with intent would remain a felony. And if that was as clear as mud, then I apologize. The statute's a little bit thorny. With respect to the one objection the association has, it relates to the lowering of the drug weights with respect to fentanyl, which it's my understanding was the only amendment that occurred during the legislative process in the House. And our concern around that is that the thrust of this legislation is to bring the penalties that are seen in the courts every day, really to bring the statute in line with the sentencing philosophies of our courts and what really happens in practice. But unfortunately, by changing the weights with regards to fentanyl, I think that this will also have the effect of more harshly penalizing certain fentanyl-related offenses. And I think that that increased punishment for those offenses really is not logical, especially in the framework of the overall legislation. And to speak to that, I just try and give the committee a little bit of practical information. In my own practice, and I would ask the committee if they're curious about these things to reach out to law enforcement, who's likely a wonderful resource. There is, for all intents and purposes, no heroin in the state of New Hampshire anymore. What I mean by that is that I've represented tens, if not hundreds of people in opiate-related cases over the last, I'd say, 4 years, and steadily from about 2017 to the present, the percentage of fentanyl rather than heroin has increased and increased such that I cannot tell the committee the last time I saw something tested as heroin rather than fentanyl. The opiates that are on the streets in New Hampshire are all fentanyl. So this bill, in essence, is increasing the penalties for possession with intent or dispensing of basically the most common street drug in the state of New Hampshire. Even though heroin is not on the street, street level dealers and users still refer to the drug as heroin. People will say, I'm addicted to heroin. I sold dope. I sold heroin. They don't, for all practical purposes, know what these substances are. They just know that it's an opiate-like substance. I think that the committee should know that, and these things fluctuate because it's a black market, but typically 0.1 gram of an opiate, now fentanyl, in the state of New Hampshire will sell on the street for about $20. The current legislation makes the possession with intent highest tier offense 0.5 grams. So in essence, it's reducing from approximately a threshold of $1,000 worth of drugs to get to that top penalty, way down to approximately $100 worth of drugs to get to that top tier felony. And I would ask the committee to think about who would be affected by this change. The people who are simple users won't be affected because they're not dispensing these drugs. The people who are high-level traffickers really wouldn't be affected by changing the threshold from 5 grams to a half a gram because they are trafficking in amounts well above 5 grams. The people that will be affected by the change in weights with respect to fentanyl are the people that Senator Gannon spoke about earlier. Very low-level users who are dispensing small amounts of drugs, $100, $150, $200 in order to support their own habits. Those people will now find themselves in the highest tier of possible punishments. And so the association would ask the committee to consider amending it back to the original purpose and keeping those drug weights the same across opiates, keeping the weight for heroin and fentanyl the same. And if you have any questions, I'm happy to answer. If not, thank you for your time.
Thank you very much for your testimony this afternoon, Mr. Odland. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Ryan Fowler. Good afternoon, Mr. Fowler.
Good afternoon, Madam Chair. Thank you. Can everyone hear me all right?
Yes, we can.
Beautiful. Thank you for your time and consideration on House Bill 615. I'm here in support of House Bill 615, reducing criminal penalties for simple possession of drugs. I'm a person in long-term recovery from a substance use disorder. I'm a certified recovery support worker. I sit on the governor's opioid task force. I'm a board member for the New Hampshire Providers Association. I have spent my 6 years in long-term recovery, working with people who use drugs, looking at this through a professional and academic lens. And, you know, what I have come to realize through my own research and, you know, lived experience of those around me, prohibition doesn't work. It's been 107 years since the Harrison Tax Act passed. 13 years of alcohol prohibition showed that it didn't work. And now we have a safe, regulated supply of alcohol. Liquor stores sell lethal amounts of liquor every single day, and we tax it and regulate it. Scheduling drugs has never stopped anyone from using. It only blocks science. And of course, I support decriminalizing simple possession of drugs. The second part of the bill, scheduling fentanyl and increasing penalties for fentanyl, really make no sense at all. There's really a lot of myths and fallacies. And really what you need to understand is that fentanyl is a product of prohibition and criminalization. And further criminalizing fentanyl isn't going to do anything but make the problem worse. What we've seen is a drug supply that went from poppies to opium to heroin to synthetics to fentanyl to carfentanil. Further criminalizing fentanyl will give us more dangerous drug supply. Criminalization only refines the drug supply. And as far as the scheduling in this bill, it's subjective and not founded in science or any research I've ever seen. It really would just criminalize low-income people. And really, in essence, I just, you know, I'm in interest of not repeating myself compared to the other articulate speakers before me, law enforcement really has no business addressing health issues like drug use. Their role in addressing this issue is taking people into captivity, taking away their rights, and keeping them in a cage. That's not public health. Traumatizing people and surveilling low-income communities is a really effective way to give us the overdose crisis and the addiction crisis. Anything that prohibition and criminalization sought to do has, you know, done the opposite. We have a worse drug supply, more overdose, more crime. And in essence, if we were to move away from criminalization towards an evidence-based model, we would save money, free up law enforcement, and enhance respect for law enforcement because we need them. They protect us, they're there for us, but nothing increases stigma against law enforcement more than criminalizing a health issue. This is a health issue, and it only makes the drug supply more harsh. So I would really advocate for simplifying the scheduling apparatus. Simplify it. We're not going to arrest our way out of the problem. We're not going to criminalize our way out of the problem. It's really about harm reduction and removing barriers to evidence-based treatment and harm reduction and science. And there's so many better things that we could be arguing over. But when you ask any drug user in New Hampshire who's using the drug supply, any pill or powder could be fentanyl. It's a drug of deception. And people who have a half a gram or a quarter gram of fentanyl are really low-level drug users. I can't tell you how many clients or participants in research I've talked to who use 5 or 10 grams of fentanyl a day. You know, criminalizing people doesn't work. And I would really advocate for passing House Bill 615 without increasing penalties for fentanyl, because the class-wide scheduling of fentanyl and related analogs are really going to block science, because this market needs better opioids. Fentanyl is a really crappy street drug, but it's a market that's existed for 5,000 years. Drugs won the war on drugs. The war on drugs is over. Drugs won. I really appreciate your time and happy to answer any questions or take any comments, and I'll be quiet now. Thank you.
Thank you very much for your testimony this afternoon, Mr. Fowler. Are there any questions from the committee? Okay, seeing none. Thank you again, Mr. Fowler. Next, we're going to go to Asma Elhouni.
Hi, can you hear me?
Yes, we can.
Thank you so much. My name is Asma Elhouni, and I am the Movement Politics Director for Rights and Democracy, New Hampshire. And I am here speaking in support of HB 615, except for the fentanyl amendment, which we believe the amendment creates more dangerous situations for those who are already those who need the most help in our state. So people have said we cannot criminalize our way out of the drug problem, and we need to shift from a punitive approach to drugs to a health-based one. This bill would have important and significant impacts on the cost of incarceration in the state of New Hampshire. New Hampshire spends $35,000 annually to incarcerate a human being. Incarcerating people who use drugs for their drug use does not have any positive impacts on their health or their drug use. The result is a waste of taxpayer dollars and significantly higher chance of overdose death once someone is released, and a criminal record that creates barriers to housing, employment, and other opportunities that could actually help people change their lives. Imagine what a difference that would make if we actually reinvest that money in evidence-based interventions, such as harm reduction programs, overdose prevention programs, and medications for opioid use. New Hampshire is currently dealing with a crisis of overdose deaths. Overdose deaths is the leading cause of accidental deaths in New Hampshire for many years. The New Hampshire overdose rate is 33.1 per 100,000 in 2018. Is significantly higher than the national overdose death rate of 20.7 per 100,000. In fact, New Hampshire had the unfortunate honor of being the state with the 6th highest overdose rate in the country. These are needless deaths, and most, if not all, could have been prevented with harm reduction interventions and compassion, not punitive response to drug use. To be clear, reducing simple possession from a felony to a misdemeanor will not significantly impact overdose deaths, HIV transmissions, hepatitis infections, or any other public health metrics, but HB 615 is an important first step in dismantling the war on drugs and reducing mass incarceration in our state. However, more change is really needed to truly impact public health outcomes. For these reasons, we are asking you to support HB 615 and removing the amendment around fentanyl.
Okay, thank you very much for your testimony this afternoon, Ms. Elhouni. Are there any questions from the committee? Okay, seeing none, thank you again.
Thank you.
And next, we're going to hear from Chief Bromsky.
Good afternoon, Senator.
Good afternoon.
Good afternoon, and members of the committee. Thank you. My name is John Brofonsky. I am the Chief of Police here in Bedford, New Hampshire. Just quickly by way of background, particularly with respect to the elements of this particular bill, I have 43 years of continuous law enforcement service. 27 of those years were spent with the United States Drug Enforcement Administration in various posts throughout the country, including the Northeast, Pennsylvania, Delaware, as well as on the Southwest border. And so I have had some extensive experience with respect to controlled drugs and substance abuse, and have seen its evolution over the past 43 years of my career. I also represent, by way of my testimony today, the New Hampshire Association of Chiefs of Police. First and foremost, I want to make sure that the members of the committee know that chiefs of police here in New Hampshire are adamantly opposed to the various elements of this bill, principally because despite some of the testimony that you heard, we strongly disagree with the notion that this bill addresses only possessory elements and quantities of some of the most lethal drugs that are flowing through the veins of the granite state as we speak every single day. There's various parts of this bill, for example, 5 ounces of cocaine, LSD, which is an extraordinarily amount of LSD, PCP or phencyclidine, and methamphetamine. Methamphetamine, members of the committee, is some substance that we have struggled with here in New Hampshire for a number of years, but it is back on the rise, principally because various Mexican trafficking cartels have decided they are going to supply very high quality, upwards of 95% pure methamphetamine through the same distribution organizations that they use to bring heroin and fentanyl to the streets of New Hampshire. And just by way of discussion with respect to methamphetamine, the last 3 officer-involved shootings resulting in deaths of individuals here in the state of New Hampshire all involve methamphetamine and marijuana, by the way, but methamphetamine as well. So to consider that the amounts of drugs discussed in this bill are nonviolent is a stark contrast with reality and what we're dealing with on the street, particularly with respect to people that are using the most lethal drugs here that are contained in this bill. Let's talk about the objection to the fentanyl elements of this bill. Fentanyl has brought us the bulk of the 3,397 deaths associated with drug overdoses in the state of New Hampshire since 2012. This past year, the latest numbers show that we are going to suffer 406 overdose deaths in the state of New Hampshire. That is a very, very slight change from the 415 deaths the year before in 2019. So we are still struggling as a state with addiction, and make no mistake about it, the quantities involved in this bill are drug trafficking quantities. These are quantities that people possess not for personal use. These are quantities that people possess for sale and distribution. And so to reduce the penalties of the bill, parts of this bill that reduces the penalties with respect to the quantities of drugs involved sends absolutely the wrong message. We're not talking about drug users. So the fact of the matter is today that most counties in the state of New Hampshire, as you well know, have drug courts, and that the prosecutors and the county attorney's offices throughout the state are routinely funneling personal use quantity arrests of individuals into drug courts, and even police agencies such as my own try our best to divert people that have personal use quantities or even no quantities of drugs, but are arrested for other property related crimes, but happen to suffer from a substance use disorder into treatment and recovery rather than into the criminal justice system. So make no mistake about it, the quantities of drugs involved in this particular bill are trafficking quantities. They are not possessory quantities. And the judiciary still needs to be able to use and leverage the higher level limits of the maximum penalties to dissuade, discourage, and to frankly send the message to drug traffickers that if you're going to sell drugs here in the state of New Hampshire that result in death and destruction and tragedy, that you're going to go to jail, and you're going to go to jail for a long time. These are not possession quantities, ladies and gentlemen. These are drug trafficking level quantities. So we also have to recognize that in addition to the quantity issue at play here, let's also consider that the utility of the criminal justice system when it comes to substance use disorder is in 2 major areas. It's one leg of a 3-legged stool with prevention, treatment, and as well as the supply side, which is law enforcement. But also let's recognize that we need to reduce the supply of the most lethal drugs here in the state. And to do that, we need to send a stark and a strong message to those traffickers involved and preserve the ability of the judiciary and give them more discretion rather than confining their discretion when it comes to sentencing. So thank you very much, ladies and gentlemen, for the opportunity to address you today. And please, if you have any questions, feel free. Thank you so much.
Thank you very much for your testimony, Chief. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Chief, for taking my question. So, I hear you on the amount issue, and that is certainly a concern of everyone's in terms of public safety. But so in reading the bill, though, the discretion issue is important, but the way that I read the bill, isn't it true that even as written, the bill retains prosecutorial discretion, so the prosecutors can determine what quantity constitutes possession?
Well, that's
Is that
true.
correct?
Thank you for your question. And
Yep.
and that is true. The prosecutors, the county attorneys that are prosecuting drug crime certainly look at quantities as the determinant as to whether or not an individual should be facing trafficking charges or simple possession charges. And in fact, I would say that this bill is attempting to correct a problem that doesn't exist. What we're correcting is a higher level limits of drug trafficking issues, whereas the drug possession limits, which are already well defined in 318B, Section 2, as already indicated, are handled quite effectively and efficiently by the county attorneys under the current system, where most drug possession charges, frankly, end up in drug courts with the recognition, which is important, having talked to hundreds, if not thousands, of people involved in suffering or in recovery from substance use disorders. They are in drug treatment, or they go to drug treatment, or they're in drug court. Why? Because the criminal justice system has leverage over them as a result of a drug possession charge. So this bill is attempting to correct a problem that doesn't exist.
A follow-up, if I may?
A follow-up, yes.
Yeah, thanks for that clarification. But it is true that the decision, I'm going to try to get this because I am a lawyer, but I have not done criminal law. But isn't it true that the decision on whether to charge trafficking versus possession, even under this bill, that remains with the prosecutor, correct?
That's true. Absolutely. Always has been.
Okay, thanks.
Okay, are there any further questions for the chief? Okay, I don't see any. Thank you very much, Chief, for your time this afternoon.
Thank you, Madam Chair. I appreciate
Okay.
it. Thank you so much.
Margaret, I've gone through the list. Are there any folks in the waiting room?
If anybody else wishes to testify, if you could virtually raise your hand. I do not see any hands.
Okay, I am going to go ahead. But before I close the public hearing, there were 90 people who signed in support of this bill and 68 who opposed. So that being said, I'm going to close the public hearing on House Bill 615 FN. That means that we have concluded our business for the day. And so I will take a motion for us to adjourn. Moved by Senator Gannon. Is there a second?
Second.
Seconded by Senator French. Okay, I will call the roll. Senator Gannon,
Yes.
Senator Whitley,
Yes.
Senator Khan,
Yes.
Senator French,
Yes.
and Senator Carson. Yes. I will let you know that I did get an email. It looks like we're going to be getting 20 more bills on top of the ones that we already have. So we are going to be a little busy over the next month or so. So everybody hang in there. We're going to get through it all, and we're going to do our jobs. So thank you all very much. Have a great afternoon, and I will see you tomorrow afternoon.